Good afternoon. This is Tripp VanderWal, an attorney with Miller Johnson in our employee benefits practice group, and want to welcome you to our third installment of our benefits lunch break series. I feel like these have been fun for us to put on. I think they've gone pretty well so far. We've gotten some good feedback. So, we're going to do a few in 2020 as a trial run and see how they went, and I'm thinking that we are going to go ahead and keep doing these in 2021. Moving on, today we're going to talk about amending our cafeteria plans for CARES Act and other COVID-19 related changes. We're doing this a little bit outside of our typical COVID webinar series because really we're taking a deeper dive into a webinar that my former partner Mary Bauman and I presented on earlier in the year. So while we'll touch on the substantive issues, we're really going to dive in more on the amendment process and specifically timelines and some problematic issues that we've identified with amendment processes. Again, so we will have some upcoming lunch webinar webinars. Here are the dates that they're planned. Again, they're the third Wednesday of every month at 12 p.m. Like we did this month, to the extent we are able, we are going to try to publicize at least a week or two out a more specific topic so that you can determine whether it's relevant for you to attend or not. I will comment right now that I think a future webinar, whether it be in January or February or both, will be kind of our thoughts and predictions on employee benefit issues, both retirement and health and welfare. We may break that up into two, but employee benefit issues under the Biden administration. Again, I think I talked about this already. There's a question and answer feature for you to post questions that I'll try to get to at the end of this, but we are trying to limit these webinars or this lunch break series to a limit of 30 minutes while you guys enjoy your lunch and hopefully learn a few things. Again, today's topic is we're going to just touch on some increased flexibility to make mid-year election changes under cafeteria plans, the extensions to some deadlines under health and dependent care FSAs, the possible increase of the maximum carryover for health FSAs, and then some issues related to reimbursement of over-the-counter OTC drugs without a prescription and certain menstrual care products. We'll probably focus our topic on that last issue. And again, also the reason that we're doing this webinar here at the end of December is to discuss whether or not or when you will need to amend your cafeteria plans. Because cafeteria plans are not things that require a whole lot of updating for legal changes. In fact, we probably haven't needed to update our cafeteria plans since potentially the ACA was passed in 2010, or for those of you that adopted carryovers in 2013 or 2014. So again, a little background, and I do want to remind you again that my former partner and I, Mary Bauman, did both a client alert on these issues and a webinar. The links to that client alert and webinar are available on our firm's COVID-19 webpage. But in May, the IRS issued two notices. One was basically just gave broad flexibility to make pre-tax election changes under Section 125 cafeteria plan, delayed some deadlines for health and dependent care FSAs. And then the second notice increased the health FSA carryover to $550 for carryovers from 2020 into 2021. And also provided that those carryovers may be increased for cost of living adjustments in the future. And then finally, the CARES Act, which was passed on March 27, I believe, now allows account-based plans, health FSAs, HRAs, HSAs, et cetera, to reimburse OTC drugs and medicine, even if those drugs or medicine aren't purchased with a prescription, and certain menstrual care products. So let's start here with the increased flexibility again with respect to mid-year election changes. So as most of you on the webinar are probably familiar with, under cafeteria plans, generally participants have to make their election before the cafeteria plan year, and those elections are arguably set in stone for the entire plan year, unless the participant incurs certain mid-year events that allow them to change. Those changes could be marriages, births, deaths. Those types of issues may allow those election changes to be changed mid-year. Under IRS Notice 2020-29, the IRS has basically said that during the 2020 calendar year, in response to COVID for a number of different reasons, we are going to allow employers to allow employees to make certain election changes mid-year, regardless of whether they've incurred an event that would ordinarily be required to make that mid-year election change. And again, let me just highlight here that these are not mandatory changes that employers have to give to their employees. They're optional. So you can say, hey, yeah, the IRS is going to let us do this, but us as the employer, the plan sponsor of the cafeteria plan, we're not going to amend our plan to allow any of these additional elections. So what is this added flexibility? So with respect to employer-sponsored health coverage, which certainly includes medical prescription drug coverage, but also appears to include coverage under vision and dental plans. An employee now in the 2020 calendar year, and again, this is the 2020 calendar year, regardless of what your cafeteria plan's plan year is, participants can make mid-year enrollments in employer-sponsored coverage, elect to change coverage options or tiers offered by the same employer, or in certain circumstances, revoke coverage mid-year. Now, let me offer a couple key considerations or key points here. Just because a Section 125 plan allows an individual to enroll or change coverage options mid-year, if it's not, the changes are requested in connection with a HIPAA special enrollment event, the carriers are not legally required to honor those changes. So if you have a fully insured plan, the insurer of your fully insured plan can say, yeah, okay, you're allowing these people to enroll mid-year, and that's permissible under your Section 125 plan, but since this individual didn't have a HIPAA special enrollment right, we're not allowing them to come up. The same is true with a switch. If you have a self-funded plan, you obviously have some more flexibility there, but keep in mind, if you do have stop-loss coverage, you may need to get approval or run that by the stop-loss carrier to make sure that if any of those mid-year enrollments get into stop-loss territory, they will provide coverage or protection. Fortunately, we found because of the COVID pandemic, most carriers and stop-loss insurers are being relatively flexible with this regard. So if you did opt to make add some of this flexibility, it's likely your insurers are willing to play ball with you. The third one is to revoke coverage. And if an employee is going to revoke medical or prescription drug coverage, really you're supposed to only allow this if the employee attests that they're going to either have or they're going to get coverage from another source. But the notice was unclear whether you needed this attestation from the employee to allow spouses or dependent children to drop coverage. So the conservative approach would probably still be to require some type of attestation that employee that a spouse or dependent child has other coverage before we allow a drop in coverage. But again, I think if you only require that for the employee, not the spouse and dependent child, you're probably in pretty safe territory. With respect to health FSAs, we could, and dependent care FSAs, we can allow people to enroll or revoke enrollment in the health or dependent care FSA mid-year, or basically elect to increase or decrease participant contributions in the health FSA or dependent care FSA. Now, a few notes about this. Again, I don't want to spend a lot of time on this because we did cover this in some significant detail in our previous webinar, but really you can't allow a decrease in contributions below what a participant has already contributed for the year. And that would be true for both a health FSA and a dependent care FSA. So really, if you allowed it, obviously, if you allowed it to decrease below what they already contributed, you'd owe these people a refund. And so these mid-year changes can't result in a refund. And with respect to the health FSA, because of the uniform coverage rule, you can't allow someone to revoke their enrollment or decrease their participant contributions below what they've already been reimbursed. So, for example, if someone, on January 2, 2020, spent their entire $2,750 health FSA election, they couldn't come to you and say, well, now I want out, or I want to decrease my participant contributions to zero. That would not be a permissible election, even with this added flexibility. Notice 2029 also allows the deadline for participants to incur certain medical and dependent care expenses for plan years and grace periods that end in 2020 to be extended until December 31. Now, keep in mind that if you have a calendar year plan year and you don't use a grace period, this added flexibility was probably not applicable to you because your calendar year actually ended on December 31, 2019. But if you have a non-calendar year plan, or if you have a health FSA or dependent care FSA that uses a grace period that ends in 2020, you as the employer can decide to extend that plan year end or grace period end to December 31 and allow people to continue to incur medical expenses until December 31, 2020, and essentially be reimbursed from their 2019 account balance to the extent that they still have an account balance. Again, these are optional changes, and this is kind of where we get a little bit more into the meat or the purpose of this presentation, and that is typically when you amend your cafeteria plans, you have to amend the plan by the end of the plan year to which the change applies in order to have a timely amendment. So if you think about this, again, use an example of a calendar year, 2020 calendar year. If you adopted any of these optional changes for 2020, in the normal course, you would have to have an amendment in place and signed, adopted or signed, I'm using those terms interchangeably, by no later than December 31, 2020. Because of everything that's going on, and I think a lot of people are still working remotely and getting these signatures are maybe difficult, or preparing these amendments may be difficult, these notices extended the time that you can adopt an amendment for these changes, and that extension goes until December 31 of 2021, so basically a little over a year from now, and that amendment can still be retroactive to January 1, 2020. So the good news is, if you decided to implement any of those optional changes that I just discussed, and again discussed in more detail in our previous webinar, you have until next year to formally adopt the amendment to incorporate those changes. So you have significant time yet. Now, let me just warn you that these are things that can easily be forgotten about when they're not at the forefront of our minds. So while you do have another year before you actually have to do these amendments, if you're thinking about this and you have some capacity to start working on these amendments or engage your TPAs or legal counsel to prepare these amendments for you, I really recommend that you start thinking about doing that sooner rather than later. It's going to be tough, especially with the holidays at the end of the year. If December 28, 29, all of a sudden you remember December 28, 29 next year, you think, oh, I need to make this amendment for all these changes I did like a year and a half ago, and you got to figure out what those are. And just don't put yourself in that situation if you don't have to. Again, these are temporary changes. They generally only apply to 2020. Moving on to another, I think, unanticipated but well-received change is the increase in carryovers applicable to health FSAs. So back in 2013, the IRS basically issued a notice that said health FSAs can have a carryover, which allows participants to carry unused account balance up to $500 from one plan year to the next. And this was actually offered not in conjunction, but as opposed to a grace period. So if you have a grace period, you can't have a carryover. If you have a carryover, you can't have a grace period. But the $500 maximum was a fixed amount. It was not increased for inflation. Notice 2020-33 said, well, we're going to change that. Now we're going to adjust the carryover amount for inflation. In doing that adjustment, the maximum carryover amount from a 2020 plan year to 2021 plan year is now going to be $550. And really the way the inflationary adjustment is calculated is it's 20% of the salary reduction limit calculated in increments of 10. So if you think about the salary reduction limit for 2020 was $2,750. It's 20% of that adjusted for increments of 10. Now, again, I will admit that math is not my strong suit, but my recollection is that the maximum salary contribution to FSAs did not actually increase from 2021. It was $2,750 in 2020 and $2,750 in 2021. So it is possible that we will not actually see an adjustment up of the carryover from 2021 to 2022. But depending on the timing and how that works, I guess that remains to be seen. But the point is that this amount will continue to be adjusted in the future. Again, this is an optional change. You don't, if you want to keep your carryover at 550, at 500, you can do so. You don't have to increase, or you could increase to 550 and say I'm going to keep it at 550, or you can basically tie it to the inflationary adjusted amount and have it automatically increase each year. Again, typically, if you're going to increase the amount of the carryover for a 2020 plan year, you would have to amend the plan by December 31 of 2020. But we have this extension that basically gives you another year to amend that and allows that change to be retroactive to January 1, 2020. Last bullet point there, it says permanent change, and really what we're getting there is, the first added flexibility changes we discussed are really only apply in 2020, unless we get additional guidance from the IRS. But this inflationary adjustment will continue to apply in future years unless the IRS says otherwise. Shifting gears a little bit, another, I think, welcome change is the ability for these account-based plans to reimburse OTC drugs and menstrual care products, in addition to all the other eligible expenses. And this was not actually done by the IRS. This was done by the CARES Act legislation. As many of you may remember, prior to the ACA, we could reimburse, FSAs, HSAs could reimburse over-the-counter drugs and medicines without a prescription, which, if you had, especially with FSAs, and you were worried about potentially losing, forfeiting your account balance at the end of the year, maybe you remember buying loads of aspirin or ibuprofen or other, over-the-counter drugs like that, just so you didn't lose that money. The ACA basically said, with respect to OTC drugs and medicine, they're only reimbursable by these account-based plans if they're actually purchased pursuant to a prescription, even if they're available for purchase without a prescription. In addition, the CARES Act added another section, or basically revised a section in the Internal Revenue Code to allow these account-based plans to reimburse amounts paid for menstrual care products. These changes were actually, even though the CARES Act was passed on March 27 or 2020, these changes were effective January 1, 2020. And again, so this was not only applied to FSAs and HRAs, also applied to these other account-based plans like HSAs and medical savings accounts. Last bullet point is really kind of the crux of why I wanted to have this presentation, and it's my understanding that most third-party administrators of health FSAs out there began allowing reimbursement of OTC drugs without a prescription and menstrual care products retroactively to January 1, 2020 as a matter of uniform administration. And they did this regardless of whether the employer plan sponsor of the health FSA even amended their plan to allow this. And I guess that brings us to why this is potentially a problem. So as I kind of touched on earlier in this presentation is proposed regulations that were issued eons ago, back in 2007, and have never been finalized. They do generally permit retroactive Section 125 cafeteria plan amendments as long as they're signed or adopted by the last day of the plan year. So again, for those of you that calendar your plan years, that's why it's important most of the time to sign those amendments by December 31, 2020. However, these regulations have this odd provision in there. It says, if you're going to add a new benefit, it can only be done on a prospective basis. Meaning to add a new benefit, you got to do that on or after the later of the date, the amendment is effective or adopted, i.e. signed. And let me just point out that the IRS has said that it's been so much time has passed since the proposed regulations have been issued that they probably can't finalize them anymore. They're probably going to have to reissue them in the proposed forms with several updates. If and when that will happen, though, is anybody's best guess. And so the question here becomes, is a plan amendment, even if I decide to sign it on December 31, 2020, that allows the reimbursement of an OTC drug without a prescription, effective January 1, 2020, is that adding a new benefit retroactively? I mean, I would say it's certainly a retroactive amendment, even though it's done at the same plan year. But I think the question is it adding a new benefit? And I think that depends on how your Section 125 cafeteria plan is drafted. And most cafeteria plans allow reimbursement of any eligible expense under Section 213D of the code, but probably had some type of restriction that said, but with respect to OTC drugs, that's only true if the OTC drug was purchased with a prescription or was insulin. So I think you have, if that's how your plan document is drafted, you have a really good argument that you did not add a benefit with respect to reimbursing OTC drugs without a prescription. You simply say, your argument goes something like this: my health FSA always reimbursed OTC drugs. I just removed the requirement that it had to be done with a prescription, and I'm able to do that retroactively as long as I amend it by the end of the current plan year. The problem, however, comes up with menstrual care benefits. Again, most health FSAs are drafted to allow the reimbursement of all eligible expenses under 213D of the code. Menstrual care products, as earlier mentioned, were actually not added as an eligible expense under 213D. Rather, there was a section 106F of the code, which in addition to 213D expenses makes them reimbursable from a health FSA, as well as an HRA, RHMSA, and HSA. I don't know why HSA is not up there. So in this context, I think if you are going to allow the menstrual care products to be reimbursed by a health FSA, you basically really can only do that after the date you amend your plan to do that. Actually formally adopt your plan to do that. At least under this kind of odd provision of the proposed regulations. And so that brings up the question, well, what do we do? Because I'm imagining that some of you already know that your administrator, whether he's told them to or not, have basically allowed all OTC drugs to be reimbursed effective January 1, 2020, and menstrual care products. Some of you may be making calls to your FSA administrators after this and saying, did you do this? And I'm guessing the answer would probably be yes. And so that raises the question again, is this going to be an issue? And I think, again, with respect to OTC drugs, we have an argument, again, based on how your plan is drafted, that this may not be an issue, but that may not be the case with respect to menstrual care products. If that is an issue and you're a conservative employer and don't want to run this risk, your next question will be, how do we fix this? And you're not going to like the answer. The only way that we're aware to fix it is basically to reprocess all these claims for at least menstrual care products as the reimbursement of ineligible expenses, and you treat that how you would any other ineligible expense, which basically means you ask the employee to repay the amount If they don't repay the amount, then potentially you withhold the amount from the employee's pay. And if you aren't able to do that, you offset it from future FSA reimbursements. And if you're not able to do that, finally you treat it as quote unquote bad debt, and it becomes imputed taxable income to the employee. Not only is that not very fun for the employer or the employee, it's an administrative challenge. Because of the pervasiveness of this problem, the fact that we understand a lot of nationwide TPAs, the real big ones that operate nationwide allow this, we're hoping maybe that they will take some effort to lobby IRS or the Department of Treasury and say, hey, you gave all this other temporary relief with respect to retroactive amendments. Will you do this too for OTC drugs, the reimbursement by FSAs of OTC drugs and menstrual care products? That's just a hope of ours. We have no idea if that's coming. Of course, if it does, we will probably host some type of webinar or at least do a client alert as soon as possible. But again, that is pure speculation. Now, just a final note, these Section 125 proposed regs really only apply to health FSAs. So retroactive amendment of an HRA to cover these products, not a problem. We don't see any problem with that. When it comes to HSAs, and for any of you who have ARCH or MSAs, those aren't really, the eligible expenses are really governed by law rather than any plan document. So the fact that the CARES Act made OTC drugs without a prescription and menstrual care products eligible to be reimbursed from HSAs and MSAs, that's automatically permissible all the way back to January 1, 2020. So again, a little bit of unfairness there. It's just kind of this weird rule in these old proposed cafeteria plan regulations. With that, again, here are the upcoming topic dates for lunch seminars. I see that I have a couple questions, and I'll try to see if I can quickly answer those and get you on your way here. So first question is, what is allowed for unspent dollars in dependent care plans for 2020? Can extensions be made into 2021? The answer to that is, if you have you can't, make sure I use the correct terminology, grace periods, which are, the ability to incur expenses for an additional 2.5 months after the end of a plan year, you can use those with dependent care. So if you don't have a grace period for a dependent care FSA, you could add that for the 2020 plan year. I have a couple clients that have already done that, are only doing it for 2020, which will essentially allow you until March 15, 2021, and to incur expenses and be paid from the 2020 account balance. Now, keep in mind, since dependent care FSAs can always have grace periods, that's nothing new. So if you're going to do this, you have to have that amendment done for a calendar year plan by December 31 of 2020. So you've got 14 days to get that amendment prepared and signed. Next question, if we have a health carryover for a health FSA, can we offer a grace period for the dependent care FSA? Yes, absolutely. So if you have a carryover for the health FSA, you can't have a grace period for the health FSA, but you can have a grace period for the dependent care FSA. Third question, over-the-counter with no prescription and menstrual care products covered under an FSA, is this mandated or optional? It is optional. Again, I think you want to, if you use a third party to administer your FSA, you want to talk to them and say, have you already started doing this automatically? And if you haven't, you can say, no, don't do it for 2020. We're a little bit concerned about this problem that this technical lawyer, Tripp VanderWal, brought up. So yeah, we want to do it. We want to do it effective 2021. Last question, did I hear correctly that the technical problem with the retroactive benefit additions regarding menstrual care products and cafeteria plan was not an issue for HSA accounts? And that is correct. This is a problem that really is only going to apply to health flexible spending accounts. It's not going to apply to HRAs. It's not going to apply to to Archer MSAs, and it's not going to apply to HSAs. What's reimbursable by an HSA is basically set by the Internal Revenue Code. So once the CARES Act amended the Internal Revenue Code, HSAs and MSAs, those expenses were automatically reimbursable out of those accounts effective January 1, 2020. HRAs, we don't see a problem with this kind of retroactive addition of a benefit because they don't fall under the cafeteria plan regulations, or HRAs are usually offered as a separate plan. So probably not going to be a problem with the HRA. FSAs, however, are almost uniformly offered as a component part of a cafeteria plan and are subject to these old Section 125 proposed regulations. So therein lies the problem. So again, not entirely equitable between these different account-based plans, but basically saying, hey, I'm going to amend my health FSA to cover menstrual care products effective 1/1/20, and signing that amendment today, I think the IRS could take a very technical approach if they wanted to and say that was a retroactive addition of a benefit. Again, with respect to the OTC drugs, depending on how your plan document was drafted, I think you may have an argument saying it's not an addition of a benefit, it's the removal of a restriction. With that, I hope you will join us for our next webinar, which is January 20 of 2021. We can all say goodbye to 2020 as it's been a rough year for everyone, I imagine. But until next time, everyone stay safe and hope you have happy holidays and a happy new year. Thanks everyone for joining. Bye now.